yet another reason why GST enforcement deserves heightened attention: the combination of civil liability and criminal overlay. Now, this is not a regime where the consequences stop at tax demand. GST combines demand and recovery proceedings on the one hand and prosecution related provisions on the other. The structure allows the matter to move from assessment type consequences into summons, search, seizure, and prosecution. Therefore, what may begin as a document request or return mismatch may, in serious cases, escalate into personal summons to directors, finance officers, compliance head, and other functionaries. So, when advising institutions today, the question is not simply whether the GST returns are in order. The question is broader. Are the transactions commercially defensible? Is the counterparty's footprint credible? Is the tax credit chain real? Is there documentary integrity? Is there a monitoring system capable of identifying artificial turnover or suspicious circularity? And if the answer to those questions is uncertain, then the institution is not merely exposed to regulatory inquiry, it is exposed to enforcement risk. That takes me to the statutory architecture. The key provisions which matter in practical GST enforcement are sections 67, 69, 70, 73, 74, and 132 of the CGST Act, read, of course, with the broader constitutional and procedural background. Let me take those one by one, not in a technical textbook manner, but from the perspective of risk and response. First, section 67, which deals with inspection, search, and seizure. Why is section 67 important? Because this is the gateway provision through which the department can move from mere information gathering into physical intervention. Once the threshold of reason to believe is invoked, the authorized officers may enter premises, search locations, inspect records, and seize documents, devices, and other material. From a legal standpoint, the threshold language matters. From a practical standpoint, what matters is that once section 67 is triggered, the institution is immediately operating in a coercive environment. Documents may be taken, devices may be seized and examined, operations may be disrupted, employees may panic, and if the response is not controlled, the institution may worsen its own position within the first few hours. Second, section 70, which concerns summons. Now, this is an extremely important provision in practice. The power under section 70 enables the authorities to compel attendance, evidence, and document production. These proceedings are treated as judicial proceedings. Many institutions underestimate the seriousness of summons because summons may appear on the face to be only a request to attend and explain matters. Now, this is a mistake. A summons is often where the factual record begins to harden. It is where statements are recorded. It is where inconsistent explanations emerge. It is where functionaries casually say more than they should. It is where the department starts identifying who appears informed, who appears evasive, and who appears vulnerable. Third, section 69, which empowers arrest. Now, arrest in GST matters is always a serious development. It signals that the matter has moved decisively into the criminal zone. The statutory trigger is the commissioner's reason to believe that offences under section 132 have been committed. The provision is significant not merely for its existence, but because its possible invocation changes the entire litigation strategy. Once arrest risk emerges, all advisory decisions must be taken with urgency and precision, which is statement strategy, document production, anticipatory safeguards where available, writ remedies, and bail planning all become relevant. Now, at this juncture, I would also like to clarify an important part. The government today uses a system called an e-office. What we may think that, okay, these particular documents have not been provided to us, or these particular documents may not exist. They don't have the authority to take my devices. They don't have the authority to arrest me or detain me. Please note that there is a record. The file has already moved on the e-office system. There is a timeline created, and different officials have already seen it and approved it. Merely because they don't have a hard copy of the same does not mean that they don't have it in real time. And while at a later date, this may be a defense which you may take that I was not provided, it may still very well exist. Fourthly, I'll come again. Section 132 which creates the offense structure. This is where fake invoices, wrongful ITC, tax evasion, and related contraventions acquire their criminal form. The practical point is that offences above the threshold of rupees 5 crores are treated as non-bailable. That is a very substantial risk marker. It means that in high value matters, the case can quickly move beyond administrative discomfort into serious liberty concerns. Now, Section 73 and 74. These govern demand and recovery, with the familiar distinction between non-fraud cases and cases involving fraud, suppression, or willful mistake. Why do these matter in an enforcement lecture? Because institutions often think that the real case begins only at the show cause notice under these provisions. In one sense, that is true because formal adjudicatory proceedings become visible there. But in another case, it is not true at all. Because by the time one reaches the Section 73 or 74 stage, the foundation has already been laid during intelligence collection, search, summons, and statement recording.